Welcome to my channel where we discuss everything and all things politics, especially about the 2023 presidential election that was held on February 25, 2023, and the result controversially announced on March 1st, 2023. And that result, because of the controversy over it, was challenged at the Presidential Election Petition Tribunal, which delivered its judgment on September 6th, and the aggrieved, not satisfied, have headed to the Supreme Court. In this discourse, we're going to look at the grounds on which Peter Obi is appealing the judgment of the Presidential Election Petition Court, which did not favor his petition in the first instance. So on Tuesday, September 19th, the Labour Party, they beat the deadline by challenging the decision of the Presidential Election Petition Court, which declared Asiwaju Bola Ahmed Tinubu as the winner of the February 25, 2023 presidential election. And we know that the court had in the ruling on the petition stated that the petitioners made generic allegations of irregularities against the respondent without specifying the polling units among the several reasons for throwing away the petition. Now, Obi and his legal team, led by Asiwaju, a senior advocate of Nigeria, they were able to beat the deadline for the filing of the appeal, and they are approaching the Apex Court on a 51 grounds, which they term an error in law, to prove that the APC, or Progressive Congress candidate, presidential candidate in the election, Bola Ahmed Tinubu, did not win the election. The appellant said that it was wrong for both INEC and the Presidential Election Court to declare him winner of the election when many incontrovertible points were proving otherwise, that he should not have been declared the winner of the election, and that the court should not have confirmed his victory. In their relief, Obi and the Labour Party, they sought from the Apex Court 4 key points: that they should allow the appeal, that the Apex Court should allow the appeal, that the Apex Court should set aside the perverse judgment of the Presidential Election Petition Court and grant the relief sought in the petition, either in the main or in the alternative. Now, on the issue of 25% requirement for Abuja, the Labour Party listed the particulars of error by the Presidential Election Petition Court as follows: that the Presidential Election Petition Court failed to appreciate that for the president to assume the office or position of the governor of Abuja is also under a mandate to secure 25% of the votes cast in the FCT. So what they were arguing is that since the president is the governor of Abuja, he has to get 25% to justify his position as the governor of Abuja, which is a position he occupies, because the president is the governor of Abuja. The minister that he appointed is running Abuja on his behalf as the governor of Abuja, as the presiding officer of Abuja. They also accused the Presidential Election Court of overlooking the fuller purport of Section 299, which will be more glaring on a calm examination of Section 301 of the Constitution. Now look at what Section 299 of the Constitution said. Section 299 of the Constitution, it stated that the provisions of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. And accordingly, all the legislative powers, the executive powers, judicial powers vested in the House of Assembly, the governor of a state, and in the courts of a state shall respectively vest in the National Assembly, the President of the Federation, and in the courts, which by virtue of the foregoing provisions are courts established for the Federal Capital Territory, Abuja. Here also is emphasizing that the President shall perform the function as if it is the governor of Abuja, performing the function of the governor of Abuja. And Section B, subsection B of that 299 said that all the powers referred to in paragraph A of this section shall be exercised in accordance with the provisions of the Constitution and the provisions of the Constitution pertaining to the matters, aforesaid, shall be read with such modification and adaptations as may be reasonably necessary to bring them into conformity with the provisions of this section. Now, the Obi and his team, they want them to understand, they're telling the court that Presidential Election Petition Court overlooked the fact that being the governor of Abuja, a Nigerian president must be able to get at least 25% of the people that is coming to govern. Okay, and if you look at Section 301 of the Constitution of the Federal Republic of Nigeria, you see that the same thing was emphasized there, that without prejudice to the generality of the provisions of Section 299 of this Constitution in its application to the Federal Capital Territory, Abuja, this Constitution shall be construed as if references to the governor, deputy governor, and the executive council of a state, howsoever called, were references to the president, vice president, and the executive council of the federation, howsoever called, respectively. It means that in the Federal Capital Territory, Abuja, the president acts as the governor, the vice president acts as the deputy governor. In other words, how do you preside over a people that they have no power over your election? They have no power over your coming into existence and presiding over them. That was why the crafters of the Constitution were deliberate in insisting on Section 134, Subsection 2B, that for you to be declared the winner of an election, presidential election, that you must get 25% in 2/3 of the 36 states of the Federation and the Federal Capital Territory. And that "and" is conjunctive. And the Supreme Court in 2008 had also insisted that it was conjunctive in Yaradua versus Buhari, and insisted that for you to win an election, you need to get 25% in Abuja. You don't need to win Abuja, but at least you get 25%. And if you look at the history of Nigeria since 1999, nobody had ever been declared the president of the country without getting 25% in Abuja. Not even under the 1979 Constitution had there been a situation where somebody became president of Nigeria without getting 25% in Abuja. The only reason why it is being tolerated now is because it was the APC that is in power, and they don't want the right thing to be done. And the Presidential Election Petition Court agrees with them. Basically, the argument that the Presidential Election Petition Court gave on why they threw away that fact that Tinubu did not get 25% in Abuja, and therefore he does not deserve to be declared the winner ab initio, because it was wrong on March 1st to be declared the winner of the election by INEC. Because before the election, Barrister Mike Igini, resident electoral commissioner, Akwa Ibom State, former resident electoral commissioner, it was a sing-song by him that nobody should be declared the winner of the election that will be held tomorrow without getting 25% in Abuja. It was a sing-song that you must get 25% in Abuja. So ab initio, Tinubu ought not to have been declared the winner of the election. If Mike Ngini, a former resident electoral commissioner of INEC, if he should know that you cannot be declared winner of a presidential election in Nigeria without getting 25% in Abuja, I can tell you for free that Professor Mahmoud Yakubu is aware of it and deliberately declared Asiwaju the winner, and then say, let us go to court and reinterpret what that 25% means. Because he cannot claim he was not aware of this thing that Mike Igini was aware of. I do not agree. It was deliberate. It was deliberately ignored. So ab initio, Tinubu ought not to have been declared the winner of the election. And since the Supreme Court had, in several rulings, interpreted that and in that section 134, the onus is on them to stand on their interpretation of 2008. They have no business changing their understanding of that and in section 134, because that and is conjunctive. The Supreme Court has ruled so in 2008. This was also confirmed by Michael Anduaka, former Attorney General of the Federation and Minister of Justice in 2008 under Yar'Adua administration. He has also said it in several interviews with Arise Television that it is a settled matter that you have to get 25% in Abuja. Now, if Anduaka is aware of this, I believe that the members of the Presidential Election Petition Court were aware of it and they deliberately ignored it. They were citing other rulings of the Supreme Court, but they deliberately refused to mention that the Supreme Court had already settled that matter of 25% in Abuja. Now that the thing is in the Supreme Court, the onus is on the Supreme Court to rely on the precedent it has said of what that and is, and use it as a ground to nullify Tinubu's election because he did not get 25% in the Federal Capital Territory, Abuja. That is the way it is. That's the only way that the judiciary can show that they are neutral on this matter, is to show proof that their judgment is based on the law, on precedent. Because this is not the first time issue of 25% was being debated. It had been an issue, and it had always been stated that you don't need to win Abuja, but you must be able to get 25% in Abuja to be declared the winner of the election. And it's not, the reason for this is not far-fetched. because the person who is the president of Nigeria is coming to Abuja to become the governor of Abuja. And at least Abuja people should be able to give him a semblance of acceptability to occupy the position of being their overlord. Now, there are other issues that Peter Obi also presented in the 51 grounds that is appealing the judgment, because Obi maintained that the Presidential Election Petition Court carried out a miscarriage of justice against him when it held that he did not specify polling units where irregularities occurred during the election. You see, this is one of the excuses that the court, Presidential Election Court, used in throwing away the petition of Peter Obi, that he did not specify the polling units in a country where we have about 176,000 polling units or more. Why don't you address the ones that he brought? At least he brought significant number of evidence to prove that there were irregularities in several polling units. Why do you insist in a huge country like this, if you are sincere with yourself as a justice, that you must pinpoint all the individual units where there were irregularities? The irregularities were even glaring by the INEC themselves, because under them, the IRIF, the results that was uploaded in IRIF, in their own IRIF, INEC IRIF, a professor of mathematics downloaded 18,088 blood results that contain nothing. Nobody can read what was there. How do you explain that? Is that not enough evidence to prove that the thing was full of irregularities? What else do you need? That 18,088 blood results, they represent results from several polling units. Do you need to identify all of them? Since INEC had already put it up on their own IRIF as authentic results, but they were blood. Nobody could read what was in them. It was out of these 18,088 blood results that they generated 2.5 million votes for Asiwaju Bola Ahmed Tinubu, with which he got 8.7 million votes and was declared the winner of the election. Now, if you subtract that 2.5 million votes that was generated from blood results, resources of 18,088, you discover that Bola Ahmed Tinubu will not have the majority of the vote cast in the election, because that 18,088 blood results ought not to have been allocated to Tinubu as part of his part of the votes he used in winning, because nobody could read what was in them. So how did INEC generate the result? How did they generate that 2.5 million votes? So Peter Obi faulted the Presidential Election Petition Court for dismissing his case on the premise that he did not specify the figure of votes or scores that were allegedly suppressed and inflated in favor of President Tinubu. Now, this is another ground. They said that Peter Obi did not they dismiss his case that he did not specify the figures of votes or scores that were allegedly suppressed. Look, Peter Obi provided all that. As I told you, the professor of mathematics, was a star witness. It was this professor of mathematics that downloaded the result sheets, the 18,088 blood result sheets from INEC IRIF, and not from outside anywhere. The one that INEC itself had uploaded to the IRIF. So what are we talking about that Peter Obi could not provide the figure? That was enough figure, and that star witness was also able to show that 2.5 million votes was generated from that blood result and allocated to Tinubu. So Peter Obi is right to raise this matter, and it's now left for the Supreme Court justices to look into the matter again and review it, because I think it was a miscarriage of justice, because Peter Obi was able to show proof. Even in this channel, I've been able to show how Peter Obi will move from number 3 to number 1. And that's based on the figures that were generated. Now look at the case of Peter Obi winning Rivers State, which had already been independently confirmed by the BBC in their calculation, by the Premium Times in their calculation. How did the Presidential Election Petition handle this? The Presidential Election Petition Court handle this? Because they don't want that matter to be addressed, what they did was to dismantle the witness and discredited the witness. So when they discredit the witness, there was no need again to consider the fact that the vote of Peter Obi was stolen in Rivers State and was stolen in Benue State, where also they discredited the witness. And now they are claiming they didn't show how they won, when Peter Obi specifically showed how he won Benue and Rivers State in figures. Peter Obi gave figures. Go and read the final written address of Peter Obi and his legal team. He gave you the figure. There are figures on how he won Rivers and on how he won Benue. And now these people are claiming, the Presidential Election Petition Court judges, that he couldn't prove any give facts and figures. It was a miscarriage of justice. And it's good that Peter Obi and his team brought it up. So that let us see what the Supreme Court will say about it, or whether they will again continue with this miscarriage of justice. So one of the grounds that Obi is appealing the judgment is that Obi is insisting that the evidence of his witnesses were wrongly dismissed as incompetent. Even the evidence of the witness that came from Amazon Web Services to prove that there were no glitches on that day. The Presidential Election Petition Court conveniently dismissed that woman, discredited that witness, so that that particular presentation by her became irrelevant. And even the court, Presidential Election Court, they were talking down on the woman, saying that she was a member of the Labour Party. But meanwhile, they accepted the witness, Michael Opayemi, Senate leader, who came as a witness for President Tinubu. When he presented his own, it was accepted as a credible witness, despite the fact he was a card-carrying member of APC. He's a elected senator. He's Senate leader. He's a close ally of Asiwaju Bola Ahmed Tinubu. But the woman that was brought from Rivers State Cross River State as a witness, who was from Amazon Web Service, they said no, she's a member of Labour Party. But Opayemi, who is a member of APC, was entitled to be witness for Tinubu. But that woman, because she's a member of Labour Party, she contested for House of Reps under Labour Party. Her evidence was discredited. It was a clear miscarriage of justice, and it's good that Peter Obi is insisting that the evidence of his witnesses were wrongly dismissed as incompetent by the Presidential Election Petition Court. It was a clear miscarriage of justice that anyone who has brain should be able to know. Now, in continuation of this, Obi told the Apex Court that the panel unjustly dismissed his allegation that INEC uploaded 18,088 blood results on each IRIF portal. Now, see, that was what I was saying earlier on. This particular matter is at the center of the thing that ought to have nullified Tinubu's election and show that he did not win majority of the votes cast in the election. Because out of this 18,088 blood result, they generated 2.5 million votes for Tinubu. Because you and I know that as I talk to you now, nobody knows the figures, how INEC was able to generate the figures with which they declared Tinubu the winner. Because even the European Union Observer Mission said so. That less than about 31, just about 31% of the votes were what was gathered before he was announced the winner of the election. And as I talk to you, several months after that election, INEC does not have the confidence of its own conviction to upload the results of the presidential election, all of them, to the IRIF. Otedo Peter side, chairman of Stanbic IBTC Bank, he drew this attention. He said, at least let INEC upload everything. Why are they still hiding the results up till now? Why is all the presidential election results several months? Why is it that 100% of them are not uploaded? And it appears there's no effort being made to upload all of them. It's all part of the gimmick of waiting until after the tribunal, after the Supreme Court ruling. Perhaps they will concoct something and put up there. So it's really strange what is happening. So P2P has a right to appeal, to draw the attention of the Supreme Court that this 18,088 blood result ought to have been taken note of. And now they presented this, P2P presented these figures and presented the fact that 2.5 million votes was generated from this 18,088 blood result. Yet, the Presidential Election Petition Court justices claimed that he was not able to show how he got the figures, how his vote was suppressed and all that. When anybody who has brain will know that this 18,088 and the 2.5 million votes that was alleged to have been generated from it, if you do the mathematics involved, you will discover that Tinubu will not have majority of the vote cast in the election. In fact, he will come a distant third if that is taken into consideration. But the Presidential Election Petition Court dismissed it, saying it's incompetent. Right now, Peter Obi is using this as a ground to appeal, and it's his right to do so, and it is a very good development. The onus is now left for the Supreme Court to do the needful in this respect. Now, Obi further alleged that the tribunal ignored his allegation that certified true copies of documents that INEC issued to his legal team comprised of 8,123 blood results. Now, the 18,088 blood result we are talking about was the one that the professor of mathematics, a star witness of Peter Obi, meticulously downloaded from the INEC archive. Now, there were 8,123 blood results that INEC handed over to Peter Obi and his legal team as certified true copies of the results. Certified true copies. So it was INEC that gave them this one. Gave them, so this is the result of the election, the certified true copy. Inside it, they counted 8,123 blood results that contain blank A4 paper, blank A4 paper, blank A4 paper, A4 papers, blank. Nothing is there. And these figures were purportedly generated from these blood A4 papers by INEC. So INEC used this blood result to generate figures with which he declared the winner. And under this blood result, they have strange images of unknown persons. Images of unknown persons was purported to be the certified true copies of polling unit results of the presidential election. Peter Obi had done the right thing by drawing attention to all these things. Now the onus is on the Supreme Court to look at his grounds of petition, which, as far as I can see, they were genuine. They ought to have been taken into consideration by the Presidential Election Petition Court, which deliberately ignored them. And was able to give Tinubu a pass, give INEC a pass, and declared that what INEC did was right and that Tinubu was validly elected in the February 25, 2023 presidential election. But there is overwhelming evidence that he ought not to have been declared the winner of the election. So many glaring evidence. I hope that the Supreme Court will be fair-minded in looking at what Peter Obi has presented. And what he has presented, if they look into it properly, there are enough grounds for the nullification of the election of Asiwaju Bola Ahmed Tinubu. But let's keep our fingers crossed and see what the justices of the Supreme Court will say, what they are going to say this time around about FCT Abuja, about the issue of INEC claiming there were glitches, what they are going to say about how they generated the figures with which they declared Tinubu winner when there were 18,088 blood result sheets which contained 2.5 million votes, which ought to have been subtracted from his vote, and so many other issues, especially the way his witnesses were treated. Out of 13 witnesses, they cancelled 10 of his witnesses. It was a clear miscarriage of justice. I believe that the Supreme Court should look into those witnesses' accounts, because those witnesses hold the edge to the truth about what transpired in the February 25, 2023 presidential election. Thank you for watching this video, and if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel, hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you will be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. Thank you, and God bless you and yours.